thank you so much for being here, for having us. I know, like Mr. Lutra, I love speaking philosophy. Not just because, like him, I'm also a student of the law, but because I believe that part of the law being lived is for us to be in conversation. Those of us who are practitioners and the bar, to be able to speak to you, and we hope you will come join us at the bar. That we are motivated and stay idealistic because of the conversation we have with you. And in turn, we would hope that you will have those conversations with your students. Being a lawyer is being a member of a guild. We are here for each other, and we are also responsible for asking both the judiciary, the legislature, and the executive questions that need to be asked. We are more than any other nation, a nation founded by lawyers, a constitution drafted by lawyers. So when any of us come to the bar, we are implicitly saying that this is the book we will live by. So thank you again for having me today, for coming out on such a full day. I'm a little luckier than Mr. Lutra. I have just come back from Hyderabad, where I helped my father celebrate his 75th birthday. It is truly, it's truly luck and great privilege to be able to have your parents with you on the journeys that we do. Now for the judgment. That is known as the Menaka Guruswamy. Now I must say that when I read the judgment, and like Mr. Lutra, but not half as eloquently as he did, I also argued against certain specific provisions of the PMLA statute. Now, I must, before I go ahead any further, I must ask you, how many of you have actually skimmed through the judgment? Yes, very good. Gentlemen here, 3, 4. Okay, don't be so skeptical. If you read some of the judgment, then come out with it. Okay, so a few of you have read the judgment. So, how many of you have read or skimmed through parts of the Constitution? Many more. How many of you have read or skimmed through the Code of Criminal Procedure? Few. So, some more the Constitution, few the Code of Criminal Procedure, and very few the judgment of the that we are discussing. Here's the connection between all three. Let's assume no one has read either of these three texts. The Code of Criminal Procedure is the people's constitution. This is our heart, but it is the Code of Criminal Procedure that stands by you when you are surrounded by a bunch of police officers asking you questions. It is the Code of Criminal Procedure that in fact gives you the ability to not sign a confession. It is a Code of Criminal Procedure that is the connection to the Constitution's protection against self-incrimination. It is a Code of Criminal Procedure that gets your legal practitioners in there. It is a Code of Criminal Procedure that makes sure that you are produced with a answer. When you are alone and you are surrounded by functionaries of the state, it is CRPC which is your home. Now, the values that we the people committed when to each other, when we came together as a post-colonial, newly independent nation state, and the values that our drafts committed, each of us do between 1946 and 1949, are codified in this, the Constitution. Key values include, in the context of the PMLA statute, the protection against self-incrimination. Key values include the right to life and liberty, that your freedom will not be taken away except by thoughtful procedural establishment. That is what the statute is. The judgment which is being discussed today speaks to the constitutionality and the non-constitutional key provisions of this statute that take away your protection against self-incrimination, that deeply burden your right to bail, which is a cardinal principle not just of criminal law, but of the founding values of this country. Why? Because if you are a post-colonial country and you have survived 200 years of brutal colonization, then you will know that many who objected, who marched against that colonization, needed that right to bail, and it was severely curtailed. Statutes like the PMLA are an irony in a free constitutional republic, and that is what we are all citizens of. We are not just citizens of a democracy. We are citizens of a constitutional democracy. That means that even Parliament is circumscribed and curtailed by the Constitution. This is not a nation where Parliament is unabridgedly sovereign. It is not Britain. It is India, where Indian Parliament is circumscribed and answerable to the Constitution. So what makes lawyers like Mr. Lusa and me uncomfortable, and many defense lawyers who argue against the constitutionality of a statute like the PMLA is not that we don't take corruption seriously. It is not that. Contrary to popular myth, we would also like a country where corruption is very and those who are responsible possible. But what makes us uncomfortable is that statutes like the PMLA not only take away well-established rights of the accused, but also conflicts who is an accused, who is a witness, and doesn't tell you before you're called into that room where your lawyers will not be present, but doesn't tell you, are you a witness, are you a friend, are you an accused, what is the complaint against you? You will never get a copy of that complaint, and you do not know who these men and women are and what they are asking of you. While all of that is happening, a very basic and in a very tough way, you are also having to prove your own innocence. The burden of proof is yours. It is extremely difficult to prove your innocence when you don't know what you are doing and responsible for. And very basic. The statute itself is fascinating because, as you know, the enforcement directorate is very active nowadays. It is almost as active as the individual. And probably a little more. I say this because you have the T20 being played against Sri Lanka, and recently played Bangladesh. You have the one-day internationals coming up, and there's a test series being planned. So you have a team A, a team B, and a team C, all for cricket. And this is all for criminal. Now, in the Lookshop, the questions were asked about how many convictions, how many raids, how much enforcement, and there's a context to this. Because in most countries, there is a very high conviction rate for white collar crimes. This is amongst the realities of many countries which have white collar legislation. There's a very high conviction rate. India is, in fact, interesting because you see that the minister answering these questions on how many convictions, how many raids, actually produced this data. In 2017-18, 4,527 prosecution cases were launched, 239 cases were disposed of by the courts, and there were 68 convictions. 4,527 prosecutions launched, 233 cases disposed of and 68 convictions. So your conviction rate is very low, 1%. That is remarkably low for white collar prosecution. It means that the agencies are initiating prosecution in cases that are so fragile, so weak, that they are not able to pass the preliminary thresholds. So why then? Because any criminal lawyer will tell you that the process is the punishment. And that is not a society. That is not a methodology that we as practitioners of law must be part of. Because the process isn't and cannot be intended to be the punishment. That is why we have the Code of Criminal Procedure. And that is why when judgments craft exceptions to the Code of Criminal Procedure, you have to ask yourself, what remains in terms of rights and duties? So this is the first big point I'd like to. Now, Mr. Lutra has dealt with the twin burdens. He's talked about the compromise right of way. There is a third facet of this PMLA statute, which in fact has to do with the contention that we raised in court that the many amendments to the PMLA legislation were in fact passed as finance acts. So I must welcome my dear friend, classmate, Mr. Bhawan. Mr. Banerjee and I have, I think, known each other since the first year of law school. So probably since we were 18 or 19 years old. And Mr. Banerjee still looks young, but I can certify to say that I'm crimsoning in on So I wanted to address this bit that many amendments to the PMLA were passed as facets of finance acts. And this, I believe, violates not just this principle of bicameralism and federalism as emphasized by the Constitution, but it also violates Articles 110 of the Constitution. And I'd like to be able to focus on this a little bit so I don't repeat what Mr. Lutra said. Now, since only a few are reading the Constitution, I should tell you what Article 110 is. And Article 110 of the Constitution of India basically deals with anything which is passed as an English. It gives you the definition of money bills. It says, for the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters: imposition of taxes, regulation of foreign money, custody of the consolidated fund, receipt of money on account of the consolidated fund, any matter incidental to any of the matters specified in subclauses A to F. Now, amendments to the PMLA were all passed as money bills. And this is something that we have challenged as part of the many petitions filed against the PMLA. And this facet of which the court has in fact said needs to be considered by a larger bench of senators. So we hope to be able to challenge this statute on those grounds that the amendments that were passed, and many of those amendments were challenged as part of the proceedings of this judgment. But those amendments that were passed could not have been passed as money bills, because if that were the case, then the Rajya Sabha has been easier. So, what is it that, in fact, this judgment, which I urge you, many more of you, what are all the various facets that you should be interested in as law students? Many facets of the Code of Criminal Procedure that are impacted. Section 50 of the PMLA, which violates the constitutional right against self-incrimination. Amendments to PMLA, which have been passed as money bills, You think about that because if something is a money bill, then you must ask yourself, can an amendment to what is basically a penal legislation be classified as a matter of a money bill? This is a question that you must ask yourself. And if it is being passed in this way, then what is the legacy or how does it burden the Constitution's understanding of federalism, bicameral, the idea that non-money bills must go to both houses of parliament, that Rajya Sabha must also be able to reflect the upper and the lower house, and how something like a penal law implicates all these questions of constitutional law. So the divisions and the demarcations between criminal and constitutional law is something that a judgment such as this also implicates. Now, I'm acutely conscious that I am close to, I'm what stands between Mr. Banerjee, Justice Singh, and you. So I'm going to take just a few more minutes. Not too much.
This is 5:30, right? That's what I thought.
Right. So I'm going to then take a couple more minutes to talk about what I thought
I
of
don't know
was.
about them, but I want to hear you. Please continue.
So I want to talk about what I thought about, what I called and what I argued in court as a discordant note of the Constitution, which is Section 50 of the PMLA. Now, first I have to ask you, how many of you are familiar with Section 50 of the Prevention of Money Laundering Act? Mr. Banerjee is not going to be silent. So since we are talking about this legislation, I think we should very briefly, very quickly look at Section 50 of the Act. Section 50 of the Prevention of Money Laundering Act says the powers of authority regarding summons, production of documents, and to give evidence. And it's a very, very important provision because it says the director shall, for the purposes of Section 13, have the same powers as are vested in a civil court. So it takes a director of the enforcement agency and shall, for the purposes of Section 13, have the same powers as are vested in a civil court under the Code of Criminal Procedure while trying to suit in respect of the following matters: discovery and inspection, enforcing the attendance of a person, compelling the production of records, receiving evidence on affidavits, issuing commissions for examination. And all persons so summoned shall be bound to attend in person or to authorized agents and shall be bound to state the truth upon any subject respecting which they are examined or make statements. So this is fascinating because the principle in Constitution and in criminal law is that you are not bound to incriminate yourself. That is what Article 20 clause 3 of the Constitution empowers you. It empowers you not to incriminate yourself. So when you are surrounded by a bunch of police officers, you do not have to say, I did this, I killed so and so, I stole so. That is a matter for the criminal process. That is a matter for a trial. That is a matter of investigation. That is a matter for the state to investigate and build its case. What Section 50 of the PMLA does is it mandates that I must tell the truth. And whose perspective is the truth? It's the agency's perspective of the truth. I want to correlate this to the statistics that we looked at as we produced in Parliament. 4,500 prosecutions initiated and 60 convictions. So, if the assumption is I have to incriminate myself, and if the assumption is that my right to bail is compromised, and if the assumption is for the statute that I must prove my innocence, then all of that is the front loading of a statutory process which ensures that that process where I am summoned, I am not told what the case is against me, what I am being charged for, I am not told whether I am a witness, or an accused, or a friend, or just a person of some interest. I am not told any of this. I am arrested. I have a diminished, a very fragile right to bail because I have these twin conditions imposed upon me. Despite all of this, when I finally get to the situation of trial, what has resulted in this entire process is a 1 to 2% conviction rate. Now, a 1 to 2% conviction rate is the general conviction rate in the criminal process. So the issue is not 1 to 2%. The issue is that unlike most other legislation, I do not have that presumption of innocence. I do not have that protection against self-incrimination. I do not have that right to the FIR or ECIR as is here. I do not have access to a manual as to how my interrogators are expected to behave. I would have access to all of that if I was just a thief, if I were a murderer. I would have access to that if I murdered multiple people. But I do not have access to this if there was an interesting copyright. That is the PMLA. And that is why I think, as law students, you will soon become lawyers, and I hope you will come to the bar and join us in that. That is why I think, as law students, you have to be accountable. One, you have to be responsible. And you have to move past it. Because it is not just about your fellow citizens, it is also about your own self-perception of who you are. Because if you are a citizen, then you must know what's needed. If you are a practitioner of law, you open the Constitution and open the community. Because that is the heart of what we do. And if you are a crafty criminal practitioner with great finesse, then open statutes like this, the PMLA, and understand what the exceptions in those statutes. And understand why that has an implication on you both as a citizen and a lawyer. Because here's the funny thing. The funny thing, as we learned after 200 years of colonialism, is that all our freedom is intertwined. Mr. Luther's freedom, Mr. Valentine's freedom, my freedom is all intertwined. When an exception is made to Mr. Valentine's freedom, then my freedom and Mr. Luther's freedom is also weakened. That's what we have done. By taking away your protection against the right to against self-incrimination, it weakens all of us. It's not just a bunch of, flashing money on this. I wish it were. But it is precedent that is created, that is upheld by the top court of this country, that in turn weakens the rest of us. And that is why we were scared about decision makers. Now, the next thing I want to talk about, I'm going to end quickly here, is that as young law students, you must have aspirations. And I'm going to take 2 minutes to ask them, what is it that you aspire? We've been talking about the judgment, and when I had the judgment, I looked for something like that. The gentleman there is taking his pencil, his movie, and I was pencil and movie, and I read the judgment. But I'm asking you now, as a middle-aged lawyer, you are all, you are a hope of the law, you are our future. What is it that you aspire? Yes. You will study law, you will graduate, and you will do what? Now to start off, I like to initiate my career as a advocate. Why? That's something I have to think more about. But that's one way of service I feel I can, give to people. I think that residency is also a kind of yes. I'm saying about that.
I wanted to solution. So,
I love solution.
so I'm going to join civil services, also around that, and in that way, I will be a graduate soon. So, my aspiration is civil service because being an IAS, being an IPS, or being in civil services, you get to solve disputes before they arise. Lawyers come to because judicial after the dispute has been adjudicated. They try to make policy buildings accurate. But in IAS also you get to be proactive. That's
Wonderful. Well,
You need to ask him Menaka where he's from.
yes, good evening. Tell us your name also.
Yeah, my name is Fragility, and just recently I became a lawyer this year only, and I'm aspiring to be a judicial magistrate by 2023 January, my resolution. And the thing after listening to you, what came in my mind, like I want to be a judicial officer. I don't want to say that tomorrow, just in few years, I will change this law, but being a judicial magistrate or a metropolitan magistrate, the thing will start from my end. So,
And you always wanted to.
yeah. So, ma'am, so that's the thing. Like, it is starting from very, from the district for the lower judiciary, the thing starts. So, if we are very eminent as a lawyer, if we are very eminent with the law, all the things that how it actually looks and how it works, so I think we can make some changes.
Friends. Friends you agree with, friends you disagree with, but it must be a diverse circle of friends. Because you don't have to agree with someone to be their friend. And the greatest fidelity or the greatest gift that you can have in your life is that of friendship. So these are the three things that I hope I will leave with you and I will ask you to think about. And once again, I want to thank the organizers for having me.